Hello, everybody, and welcome to History/Law Bite number 214, dated March the 20th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Muller versus Oregon, 208 U.S. 412, 1908. Muller versus Oregon was a landmark U.S. Supreme Court decision that addressed the subject of the constitutionality of state laws limiting the amount of hours one could work based on gender. Indeed, in this case, the state of Oregon had enacted a law limiting women who worked in factories and laundries to a working day of no more than 10 hours, which is frankly long enough, okay, in those industries especially. Okay, not everyone agreed with the law, and indeed, the individual in this case, Mr. Kurt Muller, was fined for making a female employee work longer than the statutory deadline of statutory limit, of 10 hours. Okay, he was fined $10. All right, he appealed his conviction accordingly in the Oregon courts, which sustained both the fine and the constitutionality of the state law in Oregon. All right. So after moving through the Oregon courts, the matter was appealed to the Supreme Court of the United States. Now, before I go any further, this case sounds mighty familiar, doesn't it? A law limiting the amount of hours one can work from another important case of that era. Take a guess. You got it. Lochner versus New York. Indeed, Lochner was handed down only 3 years prior to this case. Okay? And when the matter was appealed to the Supreme Court, the attorneys for Muller made essentially the same positions and points as in Lochner. That essentially the law inhibited the ability of women to contract freely and engage in lawful employment as they saw fit. However, on the opposite side, with the state of Oregon, they really geared up for battle. The National Consumers League was determined to win this case. So they hired probably the most prominent labor lawyer of the day, Louis Brandeis, all right, to advocate on behalf of the respondent, the state of Oregon, and its law, all right. The National Consumers League, all right, with prominent individuals running the organization, such as Florence Kelly and Josephine Goldmark, all right, assembled a vast amount, okay, of data, statistics, and scientific evidence, okay, affirming how women are naturally different from men. Women have different societal roles as commonly accepted and already well known at the time than men, and thus needed this type of protection in the law, not to be overworked. It could compromise their health and their ability to be wife and mother. All right. And essentially, that was the primary argument made by Brandeis. All right. From this case, you also see the creation of the Brandeis brief. Remember, we were just talking about a second ago. All right. The Brandeis brief was essentially a very voluminous brief that contained about 2-3 pages at most of actual law and about 100 or more pages of scientific data and evidence to support the legal positions that were being advocated. And indeed, that was what was presented to the court. Brandeis's argument to the court was that women were indeed special, all right, as mothers and wives, okay? Women bear children, all right? Women are more delicate than men physically, okay? And thus women needed the special protection of the law, all right here. So this law obviously was constitutional as it demonstrated a very compelling state interest in protecting the health and lives of women, all right? And thus protecting the health and lives of women, we protect the continuity of the human race. So, these positions were argued to the Supreme Court of the United States, and accordingly, in a unanimous decision by Justice David Brewer, the Supreme Court affirmed the constitutionality of Oregon's law. In distinguishing this case from Lochner, which has very similar facts, the sole difference here being that the law is targeting women here, the Supreme Court reasoned, quite honestly, that women obviously hold a very, very protected and special place in society, all right? And quite honestly, their special status as mothers and wives warranted these protections. Indeed, the law here in question, as well as virtually the laws in any other state that mirrored Oregon's, enabled women to not only work, but still fulfill their role as wife and mother. All right, so it was a very effective balancing act that the law here in question was playing. All right, the court, like I said, distinguished Lochner from this case, making it known that if such a law was targeting men, it would likely be found unconstitutional. But this was not involving men. All right, men were different. Okay, the ability of men was naturally to be the provider. Our reasoning, the court, and thus men should not have unjust restrictions placed on their ability to provide. Okay, and that is why this case was different from Lochner, because of the special interest that the state of Oregon had, the compelling state interest that Oregon had in protecting the health and lives of women. Okay, and to quote a piece of Justice Brewer's opinion, if you'd like to listen along, he wrote that women's physical structure and the performance of maternal functions place her at a disadvantage in the struggle for subsistence is obvious. This is especially true when the burdens of motherhood are upon her. Even when they are not, by abundant testimony of the medical fraternity, continuance for a long time on her feet at work, repeating this from day to day, tends to injurious effects upon the body. And as healthy mothers are essential to vigorous offspring, the physical well-being of a woman becomes an object of public interest and care in order to preserve the strength and vigor of the race. Okay, so Brewer's making a very strong argument that women need this type of special protection. Like I said, because women are wives and mothers, and because women obviously carry and bear children, they are necessary to the continuity of the human race, and thus need protection to have to prevent their bodies from being torn up and abused due to long working hours. All right. And in the industries that this law targeted, factories and laundries, obviously this is very arduous work. All right. And arduous work for a woman is not good if she plans on becoming a mother, or if she plans on having more children. All right. This type of physical stress on her body is not healthy. Okay. So obviously this law is a very responsible and therefore constitutional means of protecting the health and lives of women. Okay? Therefore, it was not in any way a violation of the Due Process Clause of the 14th Amendment, all right, as it likely would have been found to be if it was such a law limiting the amount of hours men could work, okay? So the bottom line holding in this case is that Oregon's law limiting the amount of hours women could work in certain industries to 10 hours per day was a constitutional exercise of the state's police power necessary to protect the health and lives of women. All right. The state had a compelling and responsible interest in protecting the health and lives of women. Women are obviously the bearers of children, and thus their bodies needed protection from excessive working hours. Thus, the law of the state of Oregon was upheld by a unanimous court. So, the interesting thing with this case, however, is that many people did not agree with the decision that happened to be women. All right? Many women did not agree with Muller versus Oregon, as they viewed the decision quite simply as viewing women as inferior to men on multiple levels, and thus limiting their ability to provide for themselves. Many of them argued that not all women plan to become mothers or wives, and therefore they should not have limits on how much bread they can make. Hey, in other words, you guys are not allowing the states to limit how many hours men can work. Why are you doing it to us? Okay? So the decision was well received by many, but scorned by many others. Many women, in fact. Okay? And another interesting point from this case that I think you will approve of is that the attorney for the respondent, state of Oregon, Louis Brandeis, not a decade later, would be appointed an associate justice of the Supreme Court of the United States himself by President Woodrow Wilson in 1916. Brandeis would become the court's first Jewish justice. So that's Muller versus Oregon. All right. Once again, the citation is 208 U.S. 412, 1908. And the holding was that the state of Oregon's law limiting the amount of hours women could work in certain industries to 10 hours per day served a compelling state interest in protecting the health and lives of women, all right, and was therefore constitutional according to the 14th Amendment. All right. So any questions or controversies, leave them down below. I'll be happy to answer them for you. If you liked this video, gained something from it, I hope, drop me a like. All right. If you'd like to donate financially to my channel, links are provided on the main page. Thank you all so very much for listening. I appreciate it more than you'll ever know. Take care. Stay safe out there, and I'll talk to you at the next bite. Peace.